There's a hidden danger I see all the time in older estate planning documents. I like to call it the ticking time bomb. If your estate plan was created more than 10 years ago, specifically before 2013, there's a good chance it no longer reflects today's estate tax laws. And the consequences? They can be expensive, confusing, and completely unnecessary. A lot has changed, and if your plan still uses outdated estate tax structures, you might be creating problems instead of solving them. So in this video, I want to break down what's changed in the law, what it means for your family, and how modern estate planning can actually make things simpler, not more complicated. Starting in 2026, the federal estate tax exemption will be roughly $15 million per person. This means that most families won't face any tax at all, as long as their estate stays under those thresholds. This exemption shields your assets from tax when you pass away, and it's a major shift from what the law looked like 10 or 15 years ago. Back then, the exemption was much lower, and because of that, many estate plans, especially those created before 2013, were built around complex tax strategies. Things like bypass trusts or exemption trusts would automatically kick in when the first spouse passed away, all in an effort to preserve both spouses' exemptions. These strategies made sense at the time, but for most families today, they're no longer necessary. And in some cases, they can create more complications than benefits. One of the biggest game changers in estate planning is something known as portability. Portability means that when the first spouse passes away, their exemption can be transferred to the surviving spouse. It's a way for spouses to combine their exemptions and make estate planning much more flexible. In the past, couples had to create complicated tax structures to ensure they could use both spouses' exemptions. That's where all those bypass and exemption trusts come into play. But now, with portability, you don't have to create all those extra layers in your plan just to preserve both exemptions. For most families, this means we can dramatically simplify their estate planning while still protecting what needs to be protected. Now, here's an important catch. Portability isn't automatic. To take advantage of it, you need to file a simplified estate tax return when the first spouse passes away, even if no tax is due, and that return needs to be filed within a specific time frame. The filing itself can cost several $1,000s, often upwards of $10,000, so it's something that families should carefully consider. But that cost can be worth it, especially if your estate grows over time or the estate tax laws change. That unused exemption could be incredibly beneficial down the road, even if you don't need it today. That being said, many families won't need to file at all because just one spouse's exemption is enough to shelter the joint estate. For these clients, we can keep things very simple and still offer them the same protections. Let me give you an example. I recently reviewed a plan for a couple with a $10 million estate. Their documents were drafted back in 2010, and like many plans drafted during that time, it was designed to create multiple trusts when the first spouse passed away. The goal was to avoid estate tax by maximizing both spouses' exemptions. But today, that kind of complexity just isn't necessary for most families. Even if their estate had grown to $20 million, we could still keep things relatively simple by using portability. Filing the estate tax return after the first spouse passes away allows the surviving spouse to use both exemptions without triggering all those complex tax structures that makes administrations more burdensome and expensive. So instead of managing multiple trusts for the rest of their life, the surviving spouse gets a clean, efficient plan and the same tax protection. Many modern estate plans use what I would call a hybrid approach. We structure the plan so that everything goes to the surviving spouse clean and simple. The portability election is available but not required. And we also include a disclaimer, which gives the option to create that bypass or exemption trust later on if it makes sense. This way, the family doesn't have to make complicated tax decisions right now. We leave the door open for flexibility if laws change later on, or if the surviving spouse's needs change over time. So you get the best of both worlds: simplicity today and the ability to pivot if needed down the road. So what should you do if you're not sure that your estate plan is up to date? Here are 3 practical steps that you can do right now. First, talk with an experienced estate planning attorney about your plan if it was created before 2013. Those are the ones that are more likely to include outdated tax structures, and they're at the most risk for causing unnecessary complexity for your family. Second, talk to your attorney about simplified portability planning. If your estate is under the current tax threshold, you might not need all those complicated tax structures anymore. And if your estate is larger, portability might still give you a more flexible and cost-effective way to plan. Third, ask about adding disclaimer planning to your trust. This creates flexibility. The surviving spouse can decide at the time of the first spouse's death whether to keep things simple or to shift assets into a bypass or exemption trust for tax or family reasons. It's a smart way to plan for uncertainty without locking yourself into a complicated tax structure now. These are small updates that can make a big difference. The bottom line is this: older estate plans can actually be creating issues instead of solving them. Thanks to changes in the law, especially higher estate tax exemptions and portability, many families can now simplify their documents without giving up protection. So ask yourself this: does your estate plan reflect current law, or is it a ticking time bomb waiting to go off when something happens? If you're not sure, now is the time to schedule a review. I'll help you understand what's in your current plan, what's changed, and whether it makes sense to update or simplify moving forward.